evening for a glorious moment and an occasion of first Judges Conclave on Mediation Education and a book release ceremony by Honorable Miss Justice Hima Kohli to celebrate and cherish the legacy which our Constitution has given to us since generations on a very special day that we just yesterday we celebrated Law Day and Constitution of India, that special day for us, for each one of us. It is rightly said by father of our Constitution friends that if you want to have the real existence, please have cultivation of mind. That should be the aim of everyone for human existence. So today on this occasion, first of all, I would like to thank our honorable judges, Honorable Ms. Hima Kohli, Honorable Mr. Justice Rajendra Menon, Honorable Mr. Justice Arun Bansali, sir, who is likely to join us in another 10 minutes. Honorable Mr. Justice P. Sam Koshi, Honorable Mr. Justice G.S. Kulkarni, Honorable Mr. Justice Mohammad Musta, Honorable Mr. Justice Vivek Rasya, Honorable Mr. Justice Govind Raj, Honorable Mr. Justice Kalyan Rai Surana, Honorable Mr. Justice Talwant Singh Ji, who is also going to be joining us shortly, Honorable Mr. Justice D. Bhartas Chakravarti, sir. On this day, we extend our warm wishes and heartfelt gratitude for sparing your time for this occasion, which is very important for whole team and for everyone. Thank you so much for blessing us with your gracious presence. So, and taking the program forward, we at Team E-Mediation Writing saw a quote by our father of nation, Mahatma Gandhi ji. He once said that if you want to see the real peace in the world, please start educating children. And we genuinely believe that education is the greatest source to cultivate mind, soul of a human being. And education which empowers, which gives values, human values, understanding, respect, harmony, peace in a person, that education should be planted and spread by each one of us. It should be our fundamental duty. Taking that forward, we feel that mediation is one such revolution which empowers a person with harmony, peace, human values, respect for each other, for peaceful coexistence. It nourishes our soul. It nurtures us with value. It transforms us as a person on day-to-day basis and to live in peace with our brothers and sisters on this planet. With this, we jointly took an initiative to come with a book on mediation education for our generation next lawyers, our law students, a very concise book which happens to be covering the basics of the curriculum as proposed by Bar Council of India in their recent office order, which was there not recent, just last year when they came up and they said that it should be made mandatory subject in the law colleges. So we are thankful that the country's seasoned mediators and international mediators have spared their time to pen chapters for this book. The book has 18 chapters and name of the book is Mediation Compendium. And we are so fortunate and blessed to have Honorable Ms. Justice Hima Kohli to release this book, especially for our law students, for our generation next lawyer today, this evening. Ma'am, in one of your addresses, you have once said that a true hallmarks of any good lawyer are discipline, dedication, honesty, sincerity, sincere advice to the clients. We genuinely believe, ma'am, that these are the hallmark of your entire journey, as first as advocate, then as honorable judge on the bench. Ma'am, you are our strength, you are our source of inspiration. You have always promoted and motivated each one of us in the legal fraternity and all the mediators of our country. Thank you so much, ma'am, for this. Ma'am, your words, which says that the hallmark of a lawyer is to give sincere advice to the clients. We genuinely believe now that since our country will soon have a mediation bill, we need to tell to our young generation that whenever you get yourself enrolled in future as an advocate, please make sure that you sincerely and honestly advise to your clients that mediation is also one of the finest, first appropriate mechanism where you can resolve your conflict. So these are the vision, this is the vision and hope in our heart and mind that we look forward from our law students of our country who's going to be laying the foundation of peace and peaceful coexistence. With these words, I hereby call upon Honorable Miss Justice Hema Koleji ma'am to please release a physical copy of this book, Mediation Compendium. Ma'am, please.
Very good evening. And here we go. Just the right way to set the ball rolling. Here's the book that was sent to me. And I'll open it up and share the cover with you. So we have here with us the Mediation Compendium, a guide for the generation next. Many congratulations. This is wonderful.
Thank you so much, ma'am. Before I invite ma'am to please share her views on mediation, on draft mediation bill, and on the book itself, I would request our very senior member, Mr. Thankanchan VP, to please play a short video of the entire book for the participants to know. Thank you, sir.
Thank you, Pushmam. With the permission of Honorable Justice Hema Kohli ma'am, with the permission of all of the judges and dignitaries, I shall open the book now.
Yes, please.
Yes, thank you.
Honorable Ms. Justice Hema Kohli, ma'am, please share your views, ma'am. We are here for your voice of wisdom. Thank you so much.
I will first apologize to all of you for making topsy-turvy the program that was actually scheduled by the organizers. I was to conclude with the release of the book, but with the permission of the organizers and keeping in mind that in the next 45 minutes, I have to join another mediation and arbitration workshop, which is down the line. I took the liberty of asking Pushp to permit me to start off, and I will in advance take your permission to log off sometime in the middle with no offenses meant, because I can't keep the next team waiting. We're all logging into from different parts of the country to do a curtain raiser for arbitration and mediation in Hyderabad through the International Arbitration Center. So with that, permit me to start. I'll start by addressing Justice Rajendra Menon, former Chief Justice of the Delhi High Court and Chairperson of the Armed Forces Tribunal. I've had the privilege of working with him when he was the Chief Justice of Delhi High Court. Justice Arun Bhansali, Judge Rajasthan High Court. Has he joined us? I thought he was joining in a few minutes. I'm not too sure. Justice Koshi, Judge Chhattisgarh High Court. Justice G.S. Kulkarni, Judge Bombay High Court. Justice Mohammad Mushtaq, Judge Kerala High Court. Justice Vivek Ruia, Judge Madhya Pradesh High Court. And Justice Govind Raj, Judge Madras High Court. Justice Kalyan Rai Surana, Judge Guwahati High Court. Justice Talwant Singh, Judge Delhi High Court, perhaps he has yet to join. Justice Chakrabarti, Judge Madras High Court. Ms. Pushp Gupta, Advocate Mediator and Chief Coordinator E-Mediation Writings. Mr. V. Thankachand, Advocate Mediator, Senior Member E-Mediation Writings. The entire team of the 32 state coordinators, esteemed participants, friends, members of the media. It is indeed a privilege to join virtually all of you on this platform on the occasion of the release of the book Mediation Compendium, which is stated to be a guide for the next generation, structured and presented by the E-Mediation Writings team. It is stated in the New Testament, in the 9th verse of the 5th chapter of the Gospel of Matthew, that blessed are the peacemakers, for they shall be called the children of God. Who could be a better qualified peacemaker than the mediators? Indeed, it was His Holiness, the Dalai Lama, who had quoted last year in an international mediation conference, who had stated that the planet does not need more successful people. The planet desperately needs peacemakers, healers, restorers, storytellers, and lovers of all kind. And to my mind, mediators eminently qualify as peacemakers. Mediation, we all know, is a process which is both new in terms of the emergence and the legal arena, and all in terms of its timeless universality. In short, mediation is a negotiation conducted with the assistance of a third party, who is the mediator. It assists decision-making processes that typically take form of a facilitated negotiation or a dialogue based on the principles of party autonomy, focused on the choices of parties, their interests and their needs, rather than their rights or their positions alone. We know it's a voluntary process, as parties are not under any compulsion to take a decision or arrive at a settlement. The decision ultimately made is a reflection of their choices and their priorities. I've had a cursory look at this book that was being launched today. It has 18 chapters, as Pushp just said, covering different aspects of mediation, starting from explaining the basic concept of mediation by differentiating conflict and dispute, extensively discussing the needs for alternate dispute resolution, and the processes, stages, and different styles of mediation. The publication covers all essential principles of mediation and recognizes it as a positive conflict resolution process. The topics covered range from different styles of mediation to the role of the mediator himself. So there are chapters on bargaining, negotiation, and understanding impasse and problem-solving techniques that serve as a rudimentary explanation of bargaining techniques, explaining complex techniques and peculiarities of negotiations in an easy, comprehensible manner. One of the topics that caught my eye is the role and ethics of a mediator, which is very important. It recognizes the multitude of discussions and schools of thought on ethical obligations of a mediator. Rather than a philosophical discourse on ethics, the chapter seeks to educate the reader on a real-time challenge faced by a mediator, which is imperative. There are also chapters on agreement writing that focus on the structuring and development of a pre-mediation agreement, and another one on the role of the mediator at the onset of a prospective mediation. The article on online dispute gives credit to the pandemic for accelerating the transition to digital dispute resolution. In fact, that is the flavor of the season, if I may say. ODR has really taken the entire mediation process to a different level. And in this pandemic, and even after that, it has found a place for itself. I certainly think that ODR will be the new tool that all of us will be using from time to time to resolve disputes, not only of ADR related disputes, but also for conducting courts, which will be incorporated into physical hearings that we are all ultimately looking at. So there probably will be a combination of both. We'll give ease to parties. We'll also give ease to mediators and those who can't connect because of their being in different continents, in different parts of the world, and still willing to undergo that process. It has opened new doors for sure. I've also come across the chapter on pre-institution mediation and settlement, which squarely covers the newly inserted mandatory pre-institution mediation provision in the Commercial Courts Act, because large number of disputes that can be nipped in the bud can be done so at that pre-mediation stage. Articles on chapter on Singapore Convention and its enforceability in India throws light on the statutory aspects of the ADR method. Last but not the least is the topic on mediation advocacy and the responsibilities of lawyers in mediation that unequivocally highlights the effective communication skills and explains the importance of negotiating and bargaining skills. The author has encouraged the lawyer mediators to be analytical in the approach and refrain from taking over the process, a very important aspect. I don't think I would like to do a discourse, really speaking, on the bill because we are all just going through the whole process, but I must share with you that Honorable the Law Minister only this morning had stated in the House before in the valedictory program that was conducted by the Supreme Court on the Constitution Day celebrations that the bill will soon be tabled in the Parliament and it'll come up for discussion. What the bill has today has some very interesting features. It has divided mediation into international settlement disputes and domestic ones. It has decided to set timelines for mediation, which is imperative with a maximum timeline of 90 days. There is a concept of interim mediation settlements, which will make things it perhaps may be a game changer in mediation proceedings. We talk of emergency orders in arbitration. We are talking of emergency mediations here. The mediation process, the bill talks of community mediation, which will be unique and something which we all in India are familiar with. Who doesn't know what community mediation is, with panchayats in every village, in every nook and cranny of our country, where people sit across the table and resolve their disputes instead of going to courts. There are some very unique features of this bill that also delineate the nature of matters that can't be referred to mediation at all and it should be excluded. And those that are included, what will be the basis of laying a challenge to those settlement agreements? Because we all know, particularly those who are sitting in courts, many of us here, that when the settlements come to court, and parties have signed in the dotted line, they will suddenly turn up and say that I was not really conveyed the meaning of all that was recorded. I didn't understand the nuances of the settlement. I was forced or coerced to enter into a settlement. I was misguided, so on and so forth. There are so many grounds. So which of the ones will be available to lay a challenge to it, and which ones will persuade the court to do that will also be an aspect that has been covered in the bill. So I will only wind up by taking this opportunity to again congratulate the team of eMediation Writings for having initiated this thought-provoking step of bringing into existence the Mediation Compendium, which will be a comprehensive reference for all the law students across the country. I've been informed that this is the first book on the curriculum recommended by the Bar Council of India on mediation for the LLB course. One must give credit to the team Mediation Writings for this pro bono initiative of e-classroom series on mediation education 2021 for law students all over the country. My best wishes for all your future endeavors in creating awareness, in sharing knowledge, and in giving the importance of mediation to resolving disputes, to building relationships, and thereby bringing peace and harmony into the society. Thank you so much. I intend to be here till I'm having to exit. You have to suffer me for a while longer. This is just the initiation of the discussion and not the end. Thank you, Pushpa.
Thank you so much, ma'am, for those motivating words and brief sketch of the complete book for the participants. Thank you so much, ma'am, for going so thoroughly with each article and chapter of the book. Thank you so much, ma'am. So now I take this program forward and invite Honorable Mr. Justice Rajendra Menon, our very dear former Chief Justice of Delhi High Court and presently serving as Chairperson, Armed Forces Tribunal, to share his views on whether do we need a mediation education as a core skill for other professions also, sir. So your views on this, please.
Good evening, everybody. Good evening, Justice Hima Kohli, all my brother judges from various high courts, the e-mediation writing team, and dear students who are participating in today's function. It's a beginning of a new endeavor by the e-mediation writing team, educating our law students with the concept of mediation, and with the Bar Council ready to introduce mediation as a curriculum for the law courses, what best than a book like this for the beginners? As far as the question posed by Pushp to me is concerned, yes, we have done a lot with regard to mediation pertaining to litigation and for the purpose of reducing the backlog of cases. We have also started pre-litigation mediation, but we should go further and introduce mediation in certain other areas and organizations so that even the pre-litigation mediation can be done away with. Now I say this because I have experimented on such a project recently with the help of most of the mediators in Delhi. After I took over charge as the chairperson of the Armed Forces Tribunal, I found that a lot of family disputes were coming before me, being an appellate authority to certain orders passed by the competent authorities in the forces and the central government. I would like to tell you that under the Armed Forces, under the Army Act, Navy Act, and Air Force Act, there is a provision for deduction from wages of a uniformed person. And one of the provisions is that if a uniformed person refuses to maintain his wife and children, the commanding officer and the central government has a right to deduct certain part from his salary to the extent of about 28% and give it to the wife and children for their maintenance. Now, when such orders are passed, they are subject to challenge before me in the tribunal. And I found that every day, on an average, there used to be 5 cases, all from all the 3 forces, Army, Navy, and Air Force. And when I talked to the officers, particularly my administrative members who happen to be senior officials, retired officials of the forces of the rank of Lieutenant General and all, they said, sir, yes, this is a big problem. And I tried to understand from them how they go about it. I was told that every unit, every command has a women's organization. The commander's wife is the president of the women's organization, which is known as AWA, Army Officers Welfare, Women's Welfare Association. And it is said that when such a complaint from any lady comes with regard to her husband not taking care of her, not maintaining her, the commander refers this complaint to the women's organization. The women go to the house, meet the family, discuss certain thing, come back and submit a report to the commander, and based on whatever is given by the given to the commander, he issues a show cause notice, hears the officer concerned, and then passes an order. Now, this process of counseling or negotiation, which is done by the woman, it's not scientifically backed or technically feasible. They are all mostly housewives, yes, educated, and they use their own skills and knowledge in trying to settle the issue. It struck me, why should we not introduce mediation at this stage? And when an application or a representation comes to the commander, why should we not order for a mediation into the matter and try to settle it then and there? When I discussed this with the chief of the army staff, there were security issues. And therefore, I suggested to them that why don't you train your members of your association, the wives association, or even the officers who are there in your office to become mediators. And they can enter into the mediation process and settle all these disputes. And as a go by, a first 40 hours mediation training for officers of the army was conducted recently in the month of September in the Indian Military Law Institute at New Delhi. 62 officers from the rank of majors, lieutenant general, and colonels from throughout the country have been trained. Training was done by mediator trainers from Delhi only, and I am getting feedbacks from many of them, and they say, sir, it's a wonderful concept, not only for the purpose of settlement of the dispute, but it has changed our attitude for dealing with day-to-day problem in the forces. I want to tell you one thing, what instigated me to think in such a manner. When I used to talk to my administrative members, they used to tell me, sir, this family problems which happen is a big administrative problem, and it's also affects ultimately the national security interest. We have a lot of members from remote areas of Uttar Pradesh, Bihar, Madhya Pradesh, working in the border areas. There are family disputes. Their family is staying in the remote villages. Family disputes are going on the court. And these people sitting in the border areas are always thinking about what's happening in the house. The dispute creates a lot of problem for them. They are unable to concentrate in their work. And 2 things happen. One, the security interest is compromised. And the second was that at one point of time, we used to find a lot of suicide by officers. Most of these Jawans were in the border areas. They had their rifles and guns. And in this modern age of communication, initially, letters used to come from their house with regard to the problems. By the time the letter comes, the commander sees the letter and gives it to them. The things used to cool down. But now, they are sitting in the border areas in their chalks with their mobile, and an SMS comes from their house with regard to their problem. They immediately get in contact with the family in the mobile. They neglect their duty, get in contact with them, and something disturbing happens, and they have the gun in there and they shoot it, and that's end of the game. So all these things made me think that if I can help these Jawans in resolving the dispute without waiting for the legal process to take. And if we can nip, as Justice Hima Kohli said, nip the issue in the bud itself before it goes to the court, why not we do it? And as an experiment, I have started it in the army. It's going to be a regular feature, and now slowly it will go to the Navy and the Air Force also. So what I mean to say is that having mediation and training the officers of an organization or an employees working in an organization with regard to mediation helps in resolving various issues which are there, which ultimately manifest into serious problems, not only for the person concerned, but also for the institution or the organization in its day-to-day administration. So my answer to push query is positive. Yes, mediation should not be confined only to schools, colleges, or courts and other litigation processes, but it should be adopted by employers, organizations also, where it would be useful in the administration of the organization. Thank you very much. Thank you for giving me an opportunity to expressing my opinion in this August gathering. Thank you very much.
Thank you so much, sir. Thank you so much. And it is rightly said, you can have peace in nation only if you have peace in home. So we must help our saviors who are there at borders to save us, to give us peace. So it is our duty to help our army men and other professions also in spreading peace. So taking this program forward, I'll invite Anubhuti ji from Chhattisgarh.
I request Honorable Justice P. Sam Koshi, sir. Sir?
Yes.
Sir, High Court of Chhattisgarh, sir. Sir, my question is, sir, please enlighten us on the importance of mediation education vis-a-vis our justice delivery system.
Thank you, Madam Anubhuti.
Yes, sir.
Justice Hima Kohli, Justice Rajendra Menon, my esteemed senior when I was in the legal profession before being elevated. All my brother and sister judges from the different high courts. Good evening to all. It's indeed a pleasure joining once again with the EMW team. The question posed to me is the relevance of the mediation education in today's world. As we all know, when we were students of law, what we were basically taught and brought up was that the judicial system in India was an adversarial system. We had a set of rules, laws framed, and the entire judicial system revolved within the four corners of the rules and laws. We could not have gone beyond that. Any order which was put to test, any action which was put to test, what was first to be tested was whether it is in excess of jurisdiction or not. It is here that there is a shift now being brought in by way of the new ADR system. And mediation being one of the strongest wings of the ADR. Another reason which needs to be considered is, or another fact which needs to be considered is that leaving aside the lawyers from the metropolitan cities or grown-up cities, a lawyer from a rural background, a lawyer from the district court or from the tehsil or taluka court carries a myth in his mind or has an apprehension that going in or adopting a mediation as a process for dispute resolution would be detrimental to the professional career. They may lose their professional area and they may have adverse impact on the economical front. It is here that the need for an education system where mediation is made part of the curriculum becomes all the more necessary. Apart from the judicial process, which at times and of late is a time consuming factor. Another fact which could be taught to the students is that in a judicial system, when a dispute is put into redressal mechanism, there can be multiple litigations arising from one issue or one dispute. Now, if the parties are put to mediation, all these multiple disputes that have arisen could be resolved by one discussion, one settlement. There need not be too many litigations which have to be addressed and answered. Another fact which needs to be considered is that of late the ADR system for resolving the dispute between the parties is catching up fast in the European countries and as also in the United States. But India is lagging behind, except for a few cities. For this reason also, as time is catching fast, the world has become smaller. The law students have to be taught of mediation and the other dispute resolving mechanisms other than the adversarial mechanism that we have, so that they can also consider treating it as their vocation or a profession, and it can also help the students to have another field of choice so far as their area of practice is concerned. If the students go in for litigation, it can also be agreements and the settlements that are entered into at the high level corporate level have mediation as one of the mode of resolving their disputes and settlements. And my personal view is that it is high time that mediation should be made as a part of a curriculum in all the law schools and the law universities that we have in our country. It has been brought to our knowledge by Honorable Justice Hima Kohli that the Bar Council has already proposed to have it. I hope it comes into action very soon. Thank you.
Thank you, sir. Over to Rima, ma'am.
Thanks, Anubhuti ji. Well, I'm glad to see so much inquisitiveness in our program today. And in the spirit of learning, I would now invite Honorable Mr. Justice Talwant Singh, Judge Delhi High Court, to enlighten us further. Good evening, sir. So the question for you today is, moving forward, the question is with regard to the law teachers, Your Lordship. What is, in your opinion, is the importance of specialized mediation education and training to the teachers, professors of the law, colleges in imparting mediation education to the law students? Over to you, sir.
Honorable Madam Kohli, my colleague participants, good evening. In fact, I'm traveling, I'm in Punjab right now, so I'm joining it from there. Basically, my take on this mediation teacher training is that it has to be taken up at a national level. In fact, I remember about 10 years ago in Delhi University, we organized, at law faculty, we organized a training of the trainers for all the law teachers for cyber law. I think that type of initiative is to be taken at national level, so that at least one teacher from every law college, or maybe from every law university, their deans, the directors, all the people who take, who are the stakeholders in teaching mediation at college level, they should be brought under one umbrella. They should come at a conference which may be for maybe 2 days or 3 days. In fact, the corona has now given us some leeway. So this conference can take place at National Judicial Academy under the aegis of Honorable the Supreme Court, or maybe at any other metropolitan city. Or we can have regional conferences where we have the trained mediators who should teach these teachers how to teach mediation. Because you cannot learn mediation only by going through a course book. There cannot be any other training except the practical training in mediation, as all the mediators have undergone that mandatory 40-hour course. Similarly, what I suggest is that the teachers should also undergo that course, and apart from that, the skills which are required for trained mediators, they must also know what message they have to carry, because it's not something which is against the advocates, as the speaker before me has emphasized. This is, I remember when we started mediation for the first time in TCRE court in Delhi, the lawyers came, after preparation of they destroyed, I think, the entire furniture in that mediation center, because they thought that this is something which is anti-advocate. And later on, that now the time has come that every lawyer requests that I should be there on the mediation panel, or my case should be referred to mediation, because this is the fastest way of solving the disputes. So my take on this issue is that the teachers should be taught in a methodical way. They should undergo that mandatory training of 40 hours. And apart from that, the course, when designing the course books, all the trained mediators who have got large experience in this field, their input should be taken and live case studies should be taught. Thank you very much. Jai Hind.
Well, thank you so much, sir, for your valuable insights and for shedding light on the educational facet of mediation. Now, I would like to invite Ms. Gitanjali from Bombay to carry on the program forward. Over to you, Gitanjali.
Thank you, Rima. Good evening to everybody. Namaskar. I totally agree with Rima. The vibrancy and the feel of this program is really exhilarating. So my question today is for my Lord Justice Girish Kulkarni from the Mumbai High Court. The question, Your Lordship, is with regard to education, litigants, and mediation. So the question is here, do we need to educate the litigants too? Your Lordship, in mediation to make our justice system more effective?
Thank you, Gitanjali. Good evening to all. My greetings to everybody. Honorable Justice Hema Kohli, Judge Supreme Court of India. Nice to see you on this platform for the first time. My namaskar. Honorable Mr. Justice Rajendra Menon, former Chief Justice of the Delhi High Court. My esteemed brothers, Justice Arun Bansali, Justice Sam Koshi, Justice Mohammad Mushtaq, Justice Vivek Rasia, Justice Govind Raj, Justice Kalyan Rai, Justice Talwant Singh, Justice D. Chakravarti, and respected organizers and coordinators. It's very interesting to find that on this important day, which is immediately next to the Constitutional Day, we are assembling to discuss mediation and to have the book being released by Justice Hema Kohli. I think mediation has definitely taken different dimensions of recently, and it is need of the hour that the litigants are actually taken in that direction to see that before we actually encounter with the adversarial system, we try to see that the litigation does not go to the court and some kind of resolution is brought about by mediation. As far as the question is concerned, I am certainly of the view that a fair idea as to what would be the concept of mediation is required to be given to the litigants. Now, in our traditional system, the litigants are mostly aware about the adversarial form, that they have to go to the court and the legal journey starts for any dispute. But as rightly said by Justice Singh, the first approach would be to sensitize or make aware the lawyers that they inform the litigants about the advantages of mediation. So when a brief comes to a lawyer, he should be ready for all these new situations. That first, whether a mediation is possible in a given kind of dispute, may it be a commercial dispute, maybe a family dispute, it may be any other kind of IPR dispute, or any other form of dispute which can be resolved in mediation. So that if that fair idea and as to what is this process of mediation is being made aware to the litigant, then definitely there is a likelihood that the mindset would change. Now, what is to be informed to these litigants and possibly those who are not aware about the benefits of mediation, the participative character of mediation, the informalness in which the disputes can be discussed with open mind, complete freedom to the parties to express themselves on all issues which may not be possible in a arbitration or in our regular litigation in the court, when the court only hears the lawyers. Then the involvement of experts in mediation, assuming that it is an accounting dispute or assuming that it is a family dispute, you have all experts, a psychological expert, a psychiatrist can be brought, his opinion can be taken. So assuming that it is a technical dispute, a technical expert, say a engineer or in some other technical branch can be involved, and that is how the things can be resolved. So I think the concept of mediation is far broader than what we would have in a actual adversarial system in the court or also in a arbitration, though it is an alternative form of dispute resolution. Most importantly, the duty of the lawyers and those who are actually going to advise on mediation to the litigants, the consequences of litigation, the uncertainty, the cost factors, and the hierarchy of appeals which are available, that and you don't know whether you are going to succeed, what would be the argument, what would weigh with the judge. All these uncertainties are definitely taken care of in mediation, where you are on a common platform, you openly discuss issues, and all those, possibly drawbacks we can say, which are a part of the adversarial system, are weeded out in this kind of system. So I feel that it is really effective, really important that the litigants are, made known about the advantages of the mediation concept. Now, this has also been statutorily recognized, as pointed out by Justice Kohli, that in the amendment to the Commercial Codes Act in 2018, a compulsory mediation and a period of 3 months after the institution of a suit where there is no urgency has been mandated. And parties definitely in commercial disputes can now explore. And many matters, at least in Bombay, we have seen many of the matters are getting settled. Now we have, as a High Court, we have also encouraged litigation, mediation in our trial courts. All our trial judges, those who are handling suits directly, are trained mediators. They have a compulsory mediation training. And as a portfolio judge in many of the districts where I have been so far in this journey on the judicial side, I have seen to it, and I have impressed upon the trial court judges that please make little extra effort. From the reading of the plaint, you come to know that yes, this is a dispute which can be certainly settled. And I have given my own examples that how I can, I have, succeeded in settling some of the very contested disputes before me. I can share an example with you. There was a arbitration matter before me. Urgently, the court was moved on a Section 9 petition. The dispute was between members of the family who have large businesses in Mumbai, and the main business, which was the family business, was the bakery business, the bread. So the famous logo is that Bombay rises with their bread in the morning, and it has been a very old business, more than about 60-70 years. Now there was a very serious dispute, and the parties had taken such contesting positions that it was very difficult. When I saw the dispute and it was mentioned before me, it was argued for about half an hour, 45 minutes. I saw that they are not looking face to face. The lawyers were also quite agitated on all the issues. So why not, suggest to them? Fortunately, the lawyers immediately accepted. I said that why don't you have a panel, which I suggested to them that let there be a former Chief Justice of our High Court, a senior advocate and an accountant. Let them sit down, at least apply their mind, and if these are your issues, it can be sorted out, and some method was given to them that they can proceed in that manner. And I must tell you, I could never believe that such a dispute could be resolved. In 3 sittings, the entire dispute was resolved. Consent terms were filed before the court, and I could see the smile and the happiness on the faces of all those litigants who were present in the court when the consent terms were tendered. So this is the beauty of litigation, mediation, and the whole journey of litigation which they possibly contemplated at that point of time, and receivers and injunctions and all that was avoided. So I think it is really important that all those who are coming directly in contact with the solicitors, the advocates, and those who are legal advisors in company, they should impress upon mediation to the litigants before they knock the doors of the court. Thank you so much. And it was a pleasure, and congratulations to all of you for the book. And I am sure that it would really help the students and those who are really concerned with mediation. Thank you so much.
Thank you, Your Lordship, for those sanguine words. I would now give my baton to Suresh ji to carry this program ahead. Thank you.
Thank you, Gitanjali ma'am. So now I would like to invite His Lordship, respected Honorable Mr. Justice A. Muhammad Mushtaq sir, Judge, High Court of Kerala, to enlighten on a subject. His Lordship, this is the subject. So in what other ways can education on mediation be made more effective in our country? His Lordship, we would like to hear your words, sir.
Thank you, Mr. Suresh, Honorable Justice Imakoli, and my brother judges. When I looked at the invitation, this meeting is supposed to end by 6, and I understand Honorable Imakoli has also attended another meeting. I'll be very brief on this because there are 5 more speakers to speak. Well, I'm really excited to hear the words of Brother Rajendra Menon, how we experienced, how he attempt to place mediation and armies disputes related to the army personnel. In fact, this is what, according to me, is real education. When you're talking about mediation, we try to replicate the same manner which we experience with our adversarial litigation. And I think that's the biggest problem we face. Even I looked at the first blush at the new enactment, I also thought it's also the same approach. It's another attempt to replicate what exists in adversarial litigation. And this is where we really goes fundamentally wrong. In fact, we experience Anglo-Saxon jurisprudence on adversarial litigation. And if we try to make the same approach in resolving a dispute through the mediation process, that we commit the same mistake, like we experience with the disputes in arbitration. Fundamentally, this is an issue of a notion of justice exists in society. We must identify this kind of approach with the notion of justice that ought to have been there in a society like us. This should be the fundamental approach, a cultural identification and a value-based identification. We are in a situation of transformation to a value-based society, and we have total approach. So now, first place, we think lawyers, litigation, and judges, and system. If we approach in the same manner, I think mediation will not take off in a manner which we want. Mediation every citizen should experience in first hand a mediation as a cultural value and the approach. That's what our past tradition speaks about for the mediation. In the same way, Brother Rajendra Menon trying to attend army personnel to educate on mediation. This is what we require. This is not something which all something to handle by lawyers or judges or system. Now we experience in the adversarial litigation. This is all what a civil society's requirement. This is all the understanding how civil society approach their own affairs dealing with. This is a fundamental aspect, according to me, when you are asking about education on the mediation. Should not confine the education within the classrooms or an academic syllabus for the law students. It's for the people to take forward and to bring a transformation as I said earlier, as a cultural value. It is only when we identify ourselves that our ethos are changing and our understanding on justice is changing. Then only the mediation would have a relevance in our system. So being having constraints of the time, I stopped with this remark. Unless we make a total transformation, structural transformation to identify the value-based system, we may not, the mediation may not have much significance that could have been conceived in our own ethos. Thank you.
Thank you, sir, for the valuable and enlightening words. Now, I may be permitted, I will invite Madam Neena Gare to present the subject. Thank you.
Thank you, Sureshji. Good evening, everyone. Good evening, all the dignitaries present here today. My question is to Honorable Mr. Justice Vivek Tulsia, Judge MP High Court, and also in charge of community mediation in our state. Sir, I just want to ask you, Your Lordship, can we look for those days where we can have a mediation available in every district of our country through a trained community conciliator? As it is said, Nyay Sabke Dwar. Then similarly, we can say Madhyasthata aapke apnon ke saath aapke apne shahar mein. So what do you think about this, sir?
Thank you, ma'am. Honorable Justice Hima Kohli, Justice Supreme Court,
Honorable Justice Rajendra Menon, Chairperson AFT, my senior, my guide, my elder brother, my all brother judges, respected moderators, ladies and gentlemen. मध्यस्थता आपके अपनों के साथ आपके अपने शहर में, we are working on this with the concept that every person belongs to any community or religion and he follows its rules, regulation, customs and rituals. In case of dispute with his own family member or with a community member, if any trained person of that community act as a mediator in that dispute, he will easily resolve that dispute. With that idea, our High Court and MP State Legal Service Authority has already started this project in the name of community mediation. Our Chief Justice has constituted mediation monitoring subcommittee at Jabalpur, Indore and Gwalior bench. I am in charge of subcommittee at Indore. Last month we invited members and representatives of all the communities and religions in the High Court conference hall. I am happy to inform you the representative of as many as 30 communities participated in that first introductory session. They were so happy and excited to know that such a proposal is coming from the High Court. Some of them told that they are already doing this mediation in their community, but they had no idea that this is having some recognition under the law. They have agreed to send their volunteers for 20 hours of training, and thereafter they will provide basic facility in their community building and premises. They have sent the name of 75 volunteers, and we are going to start their training by tomorrow. In other part of the state, we have already trained 176 community mediators from different communities. And at least 12 communities like Nema, Jain, Kayas, Brahmins, Bengali have trained their 176 mediators and started 28 mediation centers. So I am hopeful that we will achieve this madhyastha आपके अपनों के साथ आपके अपने शहर में very soon. Thank you. Thank you.
Thank you so much, sir. I am very sure under your able guidance, we will reach new heights in our state. Thank you so much, sir. Now I would like to invite Ms. Revati from Tamil Nadu.
Thank you, Nina. Good evening, all. This question is to our beloved judges, Justice Govindaraj and Justice Bharata Chakravarti. We have now heard about mediation for litigants and other persons. Sir, mediation education involves dialogue, negotiation, and conflict resolution education as well. Educating the children as potential future negotiators, starting at the school level, will both contribute concept of social communication and help build the culture of consensus and living together peacefully. This question is two parts, sir. One, that can we take this concept of mediation education at school level? And the other part is how? Please, sir, your inputs on that.
Good evening, all. Honorable Justice Mrs. Hima Kohli, Honorable Justice Rajendra Menon, and my brother judges and all the participants. First, I want to congratulate Justice Rajendra Menon for taking this mediation to this uniform services, defense personnel. Preaching is very easy, but practicing is very difficult. Justice Rajendra Menon has taken this mediation to a different level, particularly where we cannot approach or get inside. Honorable Justice has exercised his office, used his office to introduce mediation where there was a lot of stress. Thank you, sir, for taking to the different level. When the question comes to a question, starting the negotiators in primary and secondary school level is a very innovative idea. It's of course, we should take it to the students. Information is strength. Normally, that imbibing whatever taught to the children, school children, it will have a long-lasting effect. They will remember it forever. See that students, when they are taught in their initial levels, they will remember it. As I said, practice is very difficult. Preaching is very easy, but practice is very difficult. While teaching the children, either through moral education or different sources, or teaching them and doing mediation and meditation and mediation, these things will always remember in their mind. When you introduce the Indian legal system and methods of dispute resolution, everything, it will stay in their mind. I would also say, while teaching the students, they can form a committee, something schools have grievances committee that can be practiced. Mediation can be practiced in the schools. That will give a long-lasting impression in the students. Then the information, as a question put to Justice Kulkarni, it can be carried over to all the people, all the citizens in the country. So once you are informed of the mediation process, they'll take off very well. Justice Mushtaq also mentioned that unless you take it off from this limited judicial system to public, mediation will not take off well. Now this introduction of this mediation in school levels, particularly in primary level and secondary schools, and practicing it in their school will definitely help. It's a very welcome idea for introducing that mediation in school levels, so that learning and imbibing everything will be very easy. I would say one first step further, then it can be taken to the Parent-Teachers Association also. Both teachers and parents also will be informed of mediation, so that that will be practiced and that will bring harmony in the society from the grassroots level. I have a legal mediation Pandit, Justice Bharata Chakravarti. He'll take over.
Thank you.
Thank you, sir. My humble pranams to Honorable Justice Hima Kohli and all the honorable judges and everyone present here. I would only add to what Justice Govindarajan has just now shared. Like for my chapter on community mediation, in Chitra's book, we had undertaken a study world over. As if you see that the Nordic countries, namely Finland, Denmark, Switzerland, they have school mediation throughout in every school. In Finland, it was started in the year 2000. It's working very, very well. And in New Zealand, this project is called Cool Schools. Wherever the mediation concept is there, the school is also titled as Cool School. So it has taken off there very well. In Greece, this concept of peer mediation is there. The difference is that in Nordic countries, they are having it on the restorative justice model. So wherever there is violence between the students and, they exactly like restorative justice, they take an apology and then they make the victim to, compensate in whatever manner between the students, and they are, this is working very well. Yes, why not? In our country, it is much needed. For those of us who have, especially undergone law courses in government law colleges, we know, not only in school, like our professor in criminal law, he used to always start with the class, children, read this thing only in theory. Because many of you tend to, 323, 324, 307 practically by becoming, we know the effect of election and other things in law colleges where, communication is only through physical violence. So that happens even in the teenage level, 11th standard, 12th standard. So peer mediation is, you have some place in every school where these children can go, they can talk to each other, and the knowledge that they can communicate verbally also, and express their concerns not by anger, not by a fist fight, And especially, you know, throughout the world, bullying and these other related this thing nuisances in school is a very good candidate for mediation. And world over, this bullying is you know, is referred to mediation only by way of peer mediation, not by through elder or teacher mediation. They feel that peer mediation works better. A student mediator can communicate between the students better. And if you inculcate that knowledge at the school level, at the college level, then, you know, it becomes a culture. That's what we say. Like even in the context of mediation legislation, we say that mediation should be grown organically than by force. Now, in introducing it at school level and college level will help mediation, you know, that awareness among the general public, among every person in the society will be better, and it will help mediation to grow organically, and peace can prevail. We hope that we answered your question, Revati. Thank you.
Yes, sir. It's wonderful to know that catching the bird at the young will go a long way. And it's interesting that you have given about Finland and about the restorative justice system. Thank you, judges, for your insight. I would like to pass on my baton to Rajesh.
Thank you, Madam Revati ji. At the very outset, a very good evening to all. I, forum on behalf of Team EMW, welcome my Lord Kalyan Rai Surana, Judge High Court, Guwahati High Court. My Lord, the question for you to enlighten us is, in your opinion, what do you find suitable? Who do you find suitable to serve as community mediators?
Thank you, Rajesh ji. Very good evening to Honorable Justice Hima Koli and all other brothers on the bench, and to all the participants. Insofar as the community mediation is concerned, I find that it was started on 17 January 2009 by the Honorable Chief Justice of India in New Delhi, and the idea has picked up, and it has been followed by various organizations, and insofar as in this part, under our High Court rules, we have the civil procedure mediation, Guwahati High Court rules of 2007, where we have not taken care of the community mediation, and it refers only to mediation done through the court system, where under the rules we have prescribed people having qualifications to be empaneled as a mediator. But having heard Brother Justice Chakravarti Das ji, I think we have to acknowledge the importance of community mediation, and I think the village elders and people from the community, because in India we are still divided on community and caste basis, and only the elder members of the same community or caste would be the ideal person to take mediation on issues which are otherwise not covered by the civil procedure mediation. Thank you.
Thank you, my Lord. We are really very thankful, my Lord Justice Surana ji. In spite of his ailment, suffering from a sleep desk, my Lord is with us for this program. May I now request Anush to take over and offer the vote of thanks for the evening.
Thank you, sir. A very good evening to all. On behalf of Team E-Mediation Writings, it is my privilege to propose a vote of thanks to this illustrious gathering. I take this opportunity to thank our chief guest, Honorable Miss Justice Hema Kohli, Judge, Supreme Court of India, for sparing her valuable time and unveiling the special edition book, Mediation Compendium for Law Students. I also thank our guest of honor, Honorable Mr. Justice Rajendra Menon, Chairperson of Armed Forces Tribunal, for gracing the occasion with his presence and valuable inputs. We have been overwhelmed by the presence of distinguished honorable judges from different high courts of our country, and we are truly enriched by their valuable thoughts on the topic of today's conclave, mediation education. We are grateful to Honorable Mr. Justice Arun Bhansali, Judge, Rajasthan High Court, Honorable Mr. Justice P. Sam Koshi, Judge, Chhattisgarh High Court, Honorable Mr. Justice G. S. Kulkarni, Judge, Bombay High Court, Honorable Mr. Justice Mohammad Mushtaq, Judge, Kerala High Court, Honorable Mr. Justice Vivek Rusia, Judge, Madhya Pradesh High Court, Honorable Mr. Justice M. Govindaraj, Judge, Madras High Court, Honorable Mr. Justice Kalyan Rai Surana, Judge, Guwahati High Court, Honorable Mr. Justice Talwant Singh, Judge, Delhi High Court, Honorable Mr. Justice D. Bharat Chakravarti, Judge, Madras High Court. We are proud that Justice Chakravarti has been a part of Team E-Mediation writings and congratulate him on his recent elevation. We thank all the honorable judges for having graciously taken out their time for this event, which is very close to our hearts. The discussion held today has been captivating. The honorable judges, with their vast experience, knowledge, and brilliance, have enlightened us with their views in the field of mediation education. The responses to the questions received from the honorable judges have provided us with clarity and much needed insight. We bow down to you in humility. We sincerely hope that the book Mediation Compendium, which has been launched today, will be able to serve as a medium to spread awareness and education in the field of mediation. We proudly thank and acknowledge the contribution of the learned authors of the book. Honorable Mr. Justice G. Bharat Chakravarti, Ms. Anuja Saxena, Mr. Anup Kumar Srivastava, Dr. Gitanjali Prabhu, Mr. K. S. Sharma, Ms. Jaya Goyal, Ms. Reema Bhandari, Ms. Neena Khare, Mr. George Merlo Pallat, Mr. A.J. Jawad, Ms. Veena Ralli, Dr. Sudhir Kumar Jain, Mr. Anurup Omkar, Ms. Kritika Krishnamurthy, Ms. Uma Ramanathan, Mr. Rahim Shamji, Mr. Prashant Chandra S.N., Ms. Chitra Narayan, Dr. Aman Hingorani, Ms. Sanya Bhatia, Mr. Rohan Chatterjee, and Mr. Ayman Azim. We thank Mr. Anil Bakshi for designing a beautiful cover for the book, and Mr. Matthew from Midas Printers Kerala for printing the book with great quality in such a short span of time. We are grateful to our senior members and mediation trainers, Mr. Anup Kumar Srivastava and Mr. Sachin Jain, for helping the team in compiling the whole book. We also thank all our esteemed state coordinators who have raised pertinent and key issues on mediation for the consideration of the honorable judges. I convey our gratitude to all our guests who have attended today's conclave and graced this occasion. Your presence gives us great encouragement and strengthens our endeavor to continue with the objective of promoting, educating, and spreading awareness on mediation. Lastly, we thank Ms. Pushp Gupta, our Chief Coordinator, for her tireless efforts to convert the idea of this book into a reality. The entire team, E-Mediation Writings, conveys its respect and regards to each and every one of you. Thank you. Over to our beloved member, Mr. V.P. Thankachan.
Thank you all. Thank you, Anuj. And this book will be available from online platform Amazon and Flipkart from 6th of December onwards. So I request you to all my participants to collect the book from online platform. We'll be sending the books to our writers and chief guests and judges separately. Thank you all. And with your permission, I think we can conclude the session now with the permission of Pushp Gupta.
Thank you.
Please.
Thank you so much. Thank you, honorable judges. Thank you so much. Thank you so much. Thank you all for participating. Thank you from Team EMW. Thank you.